Hey guys, today we're going to talk about lost wills and admitting copies of a will. Now, I get a lot of clients who ask me, what happens if they lose their will? Well, if they lose their will, that means there is no will. So if there's no will, then the estate goes under intestacy law. You can watch the video on intestacy law below. What happens if the original will is lost, but you have a photocopy of the will? Well, then you have to take out an application. This is done before probate. You have to take out an application to admit a copy of the will. The applicant has to prove to the court that the copy of the will is the original will. And the applicant has to rebut the presumption that the original will has been destroyed. Because if there's no original will, the law presumes that the will was torn up and destroyed by the testator. So you have to convince the court that it was actually lost and not destroyed by the testator. So how is this application made? It has to be done by summons, to admit a copy of a will. The summons has to be accompanied by an affidavit of due execution and accuracy. If the applicant taking out the summons is the executor under the will, the applicant has to give an affidavit, a sworn statement, giving details why the original will is missing. The details have to be very convincing to the judge. Also, the court requires consents from all those people who will be prejudiced from admitting the lost will. What does this mean? For example, under intestacy law, a man with a wife and 2 children dies. Half of the assets go to the wife. 25% goes to each child. So if a man does a will to give all his assets to the wife, that means that under intestacy law, the 2 children would be prejudiced because everything goes to the wife. They would have gotten 25% under intestacy law. But because of the will has been lost, you need the 2 children who would otherwise benefit under intestacy law to consent to admitting a copy of the will. But the court has the power to dispense with the necessary consents if there are valid and justifiable grounds for doing so. In respect of the affidavit of due execution, you can watch the video on affidavit of due execution over here. What happens if the witnesses to the will cannot be found? Well, there's a possibility that if the witnesses to the will cannot be found or are dead and cannot give affidavits on due execution, then there's a possibility that the application to admit a copy of the will not go through. Once a summons is filed, the court will schedule a hearing whereby the lawyer will go down and discuss with the judge, present his arguments before the judge, and the judge may ask questions, and the lawyer may have to go back to get instructions from clients to file further affidavits or include further information. If the lawyer is lucky, the judge will grant an order in terms. Once an order in terms is granted by the judge, the lawyer can proceed to take out the normal probate application. However, when the probate is extracted, it will not be a normal grant of probate. It will be a grant of probate which will be limited until the original will is admitted to probate. So thanks for watching this video on lost wills and admitting copies of wills.